Lordship, indulgence in mentioning part 2, item number 10, Lordship, with a joint prayer made by both the parties. Part 2, item number 10.
Yes,
This may be taken up after a week, Lordship.
on the joint request,
Yes.
matter stands deferred to be listed after 2 weeks. Item 10, part 2. Yes.
May I seek indulgence in mentioning item number 13 of part 2, Your Lordship.
Part 2,
Yes, Your Lordship.
item number
13.
13.
Yes. If the matter may kindly be listed after 2 weeks, Your Lordship.
Yes, Mr. Malhotra. Item 13, on the request made on behalf of the parties, matter stands deferred to be listed after 2 weeks.
Also, Your Lordship, may I make the same prayer for item number 14 and 19 as well?
Part 2,
Yes, Your Lordship.
14 and 19.
Yes, Your Lordship.
All right, same prayer, same order. Yes.
Deeply obliged.
May I please, Your Lordship, may I make a mention regarding part 2 of item 18? The matter may be come up on first week of September, my lord.
Item 18,
Yes, my lord.
counsel for the appellant, writ petitioner,
Yes, my lord.
submits that the matter be deferred to be listed in the first week of September. Prayer
all
make
right.
is allowed. Relist accordingly.
Daily list for motion, item number 1.
Yes.
May please, Lordship. Lordship, in this writ petition, the petitioner is seeking for appropriate direction for granting of family pension of the petitioners, Lordship, her late father, Lordship. And the petitioner was born on 19 November 1985 out of the wedlock between Ngur Puilala Silo and Lalram Moi. And the petitioner's father was working as the junior engineer under the Public Works Department, Government of Mizoram. And the petitioner had married Sri Lalma Soma in the year 2004. However, Lordship, the parties were divorced in the year 2009. By way of sumcho, which is one of the valid grounds of divorce as per Mizo customary law, Lordship. And the petitioner father died in the year 2010. So the petitioner was divorced prior to the death of her father, Lordship.
Father's death.
Yes, Lordship. The petitioner was divorced in the year 2009 and her father died in the year 2010. So 1 year prior to the death of her father, she was divorced. And after the death of her father, the family pension was enjoyed by the elder sister of the petitioner, Lordship, Elizabeth Sai Ming Thangi. However, Lordship, the Elizabeth Sai Ming Thangi died in the year 2018. And after that, no family pension has been sanctioned to anyone from the said family. And the petitioner had approached the respondent's authority and she had submitted all the required documents. And in spite of that, Your Lordship, the family pension was not given to the petitioner, though she is eligible and entitled to receive the same, Your Lordship.
All right. Who's for the respondents? What do you submit?
Yes, Your Lordship. On perusal of the petition submitted by the applicant, it can be seen that from paragraph number 10, Your Lordship, that the concerned department has requests the petitioner to submit some original documents, which has not been submitted by the appellant. And after that, the appellant has submitted a representation dated 25/2/2025, which is still pending before the competent authority, Your Lordship. So it can be seen that there are some disputed fact. And the reason why the pension has not been released, there are some disputed fact, Your
You
Lordship.
get your instructions, will issue
Yes, Your
notice for the
Lordship.
time. Heard
Yes.
learned counsel for the parties. Petitioner is the daughter, only surviving daughter of late
Ngur Puilala.
so and so,
Oh,
who was serving as junior engineer in PWD Kolasib division from 8/2/1973 till his untimely demise on 19/1/2010. So, the family pension earlier was enjoyed by the elder sister of the petitioner, namely Ms. Elizabeth Saiming Thiangi. And however, he also passed away on 12/12/2018. So, petitioner is the only surviving legal heir of late Ngur Lala. It is submitted that the petitioner was married in the year 2004. However, subsequently, there was a divorce between the petitioner and her husband in the year 2009. Therefore, as on date, the petitioner, this divorce was prior to the death of the father, late father of the petitioner. Stop. Petitioner was solely dependent on her late father's income, and subsequently, she was looked after by her elder sister, who was in receipt of the family pension in respect of the services rendered by their late father. Stop. As on date, she is still unmarried and has no sources of income till date. Therefore, she satisfies the requirement of being a dependent daughter in respect of the government employee, namely late so-and-so. Her applications have been submitted before the authorities. However, the PPO has not been issued in her favor. Being agreed, he has approached this court. Para Ms. So-and-so, learned government advocate, submits at this stage that she would like to complete her instructions in the matter. Accordingly, para let notice issue returnable 3 weeks. Since the respondents are represented by the learned government advocate, notices are waived, however, extra copies be furnished within a period of 1 week from today. Respondents will complete their instructions and file affidavit if so advised in the meantime. Released after the returnable date.
Obliged.
Item number 2.
My lords, I appear on behalf of the outstation lawyer arguing counsel. My lords, he's requested me, my lords, to, if your lordships could have this matter on Monday.
Monday.
Yes, my lords.
All right. Monday.
For final hearing, my lords.
That we can't guarantee, but
Yes,
we'll
yes,
try to
my
have
lords.
it on Monday.
My
What is the
lords.
issue about?
My lords, here, my lords, we're challenging the show cause notice issued to the BSF personnel, who is a constable. And my lords, this is done in flagrant violation of the rules of the BSF. And also, my lords, one particular order of the commandant himself, whereby an opportunity was to be given.
There's a criminal proceeding pending.
Yes, yes. Still going on, my lords.
What is the status?
My lords, prosecution evidence.
Hmm?
Evidence of the prosecution, my lords.
Evidence.
Yes.
And what is the status of the departmental proceeding? There's a stay.
My lords, there's a stay.
There's a stay.
Yes.
All right. We'll have it on Monday.
My lords, just one prayer at this juncture, my lords, is that, my lords, the petitioner is not being allowed to meet his advocates and attend the court hearings before this honorable court. So if your lordships may summon him on Monday, my lords.
Why? Why is it required to be? We'll furnish him the online.
My
He
lords,
can have a look. That's the whole purpose of virtual.
yes, my lords, if that can be reflected, because that also is being, my lords, not given to him, my lords.
No personal appearance is required, my lord. No personal appearance is not required, my lord.
Personal appearance is not required. You
Because his
contact the registry and take the link, supply it to him. Why is an order unnecessary?
My lords, he's been denied
No,
movement. outside
denied
the
what? He doesn't have any access to mobile phones and anything. Nothing. Is he in prison?
My lords, we'll
He's
take
in
that.
custody.
My lords, the only issue is he's not being allowed to move outside the camp.
He need not. Is he inside the prison camp or a camp prison or any other?
No, my lords. He's in the camp.
He has access to telephones.
He
Then
does.
you give him the link. He can see the court proceeding.
We'll exercise that liberty. my lords.
Yes. Why his presence is required here? Unless he says that he wants to be a petitioner in person. In which case, we don't need to hear you.
Nice one. My lords, will exercise that liberty.
You contact the registry. You don't need any order for that.
Madam.
It's available. All right. Monday,
Obliged.
on the request made on behalf of the counsel for the petitioner. MS Learned CGC appears for the respondents.
Item number 3.
You ask the ladies who were standing behind, you will want to see, let them sit. Chairs are empty. Yes.
As per last court's order, we have applied for airship certificate for the petitioner, and it's in the process of we're in the process of obtaining the same. So if your lordship can 2 weeks time to have the airship certificate. For
You
the
want 2 weeks time for?
obtaining the airship certificate. We have applied for the airship certificate.
Sorry, I have not been able to understand. What you want?
We want 2 weeks time.
Yes, Your Lordship, as per order 21/5/2026, the petitioner are granted time to submit the airship certificate.
The airship certificate.
Yes.
Okay. Counsel for the petitioner renews his prayer for further time to complete instructions in respect of the airship certificate that he was required to submit before the authorities,
Before the honorable court. Your
Before this
Lordship.
court?
Yes, before this court.
before this court as directed by the earlier order dated 21/5/2026. Matter be relisted again after 2 weeks. Respondents are represented by the learned government advocate.
Item number 4.
I seek your lordship's indulgence, your lordship. If I may be given a week's time to file a short reply, affidavit filed by the private respondents and the state respondents.
Mr. Malhotra, counsel for the petitioner, renews his prayer for further time, week's time,
Week's time.
a week's time to file the rejoinder to the affidavit filed on behalf of respondents 6 to 17.
Yes, and 1 to 4, your lordship.
The affidavits filed by the respondents. Prayer made is not objected to by the respondents. Release this matter after 1 week.
I'm open.
Item number 5.
My lord, I appear through VC.
Yes.
My lord, I appear for the respondent numbers 2 and 3. So, my lord, if I may be allowed 1 week's time to file the affidavit in opposition.
You're representing respondents
My lord, in 2 and 3, my lord.
2 and 3.
Yes.
Any objections?
No, Your Lordship.
Counsel, respondents 2 and 3 is represented by the counsel who enters appearance through VC. He prays for 2 weeks' time to file his counter. Prayer made is not objected to by the counsel for the respondents. Release this matter again after 2 weeks. Learned government advocate appears for the respondents.
Number 1, Your Lordship.
1.
Much obliged.
Released
Deeply
after
obliged,
2
madam.
weeks.
Item number 6.
My lord, in item number 6,
Yes.
I appear for the petitioner, my lord.
Yes.
And we have recently received the affidavit in opposition filed by the respondents. So, my lord, if we may be given 2 weeks to file our rejoinder, my lord.
Counsel for the petitioner appears through VC, submits that he has received the affidavit filed by the respondents and prays for 2 weeks' time to file his rejoinder. Prayer made is not objected to by the counsel appearing for the respondents. Release this matter again after 2 weeks, by which time the rejoinder affidavit be filed as prayed for.
Deeply obliged, my lord. Deeply
Item number 7.
First, my lord, I'm challenging this succession order, my lord, which is passed on 3/7/2025, my lord. Here, my lord, I am the daughter who was not issued any notice when they file an application under section 30. So they have suppressed the material before the trial court. Now, and they never issued. The objection was only given by the mother and the other daughter. The family tree which is mentioned is at page number 5, my lord. My lord may have it. Helen Rosami is the first wife, and there are two sons and one daughter. The daughter, Juliet, has come before this honor, your lordship, because she never received any notice, my lord. And they have suppressed this before the trial court. Now, my lord, the one more fact I want to mention, my lord, is that the RFA has been filed. Actually, my lord, the item number 8 and 7 are connected matters, my lord. So, RFA has been filed challenging the will. Now that saving account, the section certificate.
Was the probate granted?
Probate was not granted, my lord. Probate was not granted. Probate was cancelled, and we have challenged this order before your lordship. Now, my lord, that succession certificate, which in respect of that saving account number 2009-429, where the succession order which your lordship may find in page number 18, annexure A. That saving account number is under challenge in the RFA, which is the item number 8, my lord. Now that RFA, we have received a status quo, but we have filed this RFA. After that, they have filed an application. They have suppressed before the trial court that no RFA or anything has been challenged, my lord. So, my lord,
You are saying that the order dated 3/7/25 was granted by the Civil Judge Senior Division,
yes, my lord.
purportedly on facts which were not correctly placed before the court.
Yes, my lord.
Regarding
RFA was
the-
filed, my lord may have the dates, my lord.
But this is independent of the challenge made to the will. You're challenging the will in the RFA.
That item number 8, my lord. That may be tagged along, my lord, because in RFA, item number 8, the will, the saving account is also part of this estate, my lord.
All right, so there's a status quo there,
There is status quo also, my lord. So, my lord, what has
still
happened?
subsisting.
Yes, still subsisting, my lord.
All right, heard Mr.
A.R. Borua, my lord.
A.R. Borua, counsel appearing for the petitioner.
My lord, it's my humble prayer, my lord. Prayer number 2, my lord, which is at page number 13 of this petition, my lord. The pending hearing final disposable of the present appeal direct the respondent number 1 to deposit with the registry of this honorable high court to deposit the amount, my lord.
Why?
Because he has withdrawn the amount, my lord.
The amount is already withdrawn.
The amount has been withdrawn after getting the order of the settlement.
That also will require a notice. Why should we? Heard counsel for the parties.
The notice was issued.
This-
The notice was issued, and they have received the notice, my lord.
In this matter,
Yes, in this matter.
notice was issued.
Yes, and it has been received, my lord.
All right. What is the position on steps? You've taken steps.
Yes, they have taken steps. Notice is issued. They have received the notice on in the month of July, my lord.
There is no indication what is the steps.
On page number 1, my lord may have it.
AD card has not been received back.
But the on the basis of postal receipt, it has been received.
That is not indicated here.
It's above the AD card prayer, my lord. That portion has been written. Postal card.
Postal receipt has been received.
But they have not.
Where is the C file? Who's for the State Bank? Is there a counsel for the State Bank? Have you taken steps on the State Bank? The account is in the State Bank, isn't it?
State Bank, State Bank.
Then have you served copies on the State Bank?
Not yet, ma'am.
Then it doesn't contain the postal receipts. Is there any postal receipts? Not here. Heard counsel for parties in deference to the, by earlier order dated 13/7/26, notice was issued, steps were directed to be taken. Stop as per office note, steps were taken on respondent, on the respondents. Stop, however, ID card for respondents 1 to 4 has not been returned till date. In respect of, however, by office note 27/7/26, it is seen that postal receipt for service of notice on respondent 1 to 4 has been received and kept in the C file. Stop, however, these postal receipts are not found in the C file. Therefore, registry will make necessary endorsements as to whether the service is it here? Okay. The postal receipts are available in the C file. From the postal receipts, it appears that the respondents are in receipt of the notices issued by the court. We have not arrayed SBI as a party.
No, we have not bid the SBI as part.
Then
Because our main grievance is with regard to the James.
but the amount, the account is there in the SBI.
Yes, madam.
Then,
We'll take the necessary steps if required, madam.
but you have not arrayed them as a party.
But we'll make an amended cost title.
It's up to you.
But my lord,
Counsel for the petitioner submits that he would like to array the bank authorities in which the concerned account, being savings account number so and so, belonging to their deceased father, was maintained. So, considering the fact that notices are issued and the postal receipts available on the record show that the delivery has been received by the concerned respondents, we permit 2 weeks further time for their appearance in the matter, failing which the matter will proceed ex parte.
your lordship, respondent number 2 has expired, my lord. So we
You
just
bring
got
in-
the information and we'll file the amended cost title with regard to the.
The counsel for the petitioner also submits that the respondent 2 in the meantime has expired, is required to take steps to bring in the legal heirs, if so advised. Released after 2 weeks.
Let the matter date may be fixed, my lord.
You give me, you tell
22nd of September.
22nd of September.
And my lord, item number 7 and 8 may be tag along, my lord. Because just
This is item number 7.
Seven.
It is submitted that item number 8, which is RFA number so and so, is also connected. Therefore, item 7 and 8 be listed together on 22nd of September as prayed for.
duly observed.
Item number 9.
Yes.
May it please, Lordship, Lordship, we have been permitted by this honorable court to take fresh step by way of dusty against respondent number 20. However, Lordship, despite our best effort, we are unable to track the exact location of the said respondents. So if your Lordship may kindly permit us to publish in newspaper.
Counsel for the applicant submits that they were permitted to take fresh steps at the correct address of respondents 2 and 3
Yes, Lordship.
by order dated 23/7/26. Stop. However, the correct addresses of the said respondents who are shown to be residents of Aizawl,
And Saitwal district.
2 and 3,
Yes, Lordship.
residents of Aizawl and Saitwal district respectively are not known. Therefore, the council submits that he be permitted to take steps by substituted means and by publication in the newspaper. Accordingly, steps be taken by substituted means by publication in 2 newspapers, one in vernacular and one in English, having sufficient circulation in the districts of Aizawl and Saitwal. Let the matter be, the petitioner will file affidavit of compliance and also enclose copies thereof of the concerned newspapers in the said affidavit. Matter be listed again after 6 weeks.
DB obliged.
Item 10.
May it please, Your Worship.
Yes.
This is an application for impleadment of the UGC as a respondent number 4 in the present writ petition. Your Worship, on the last date of hearing, after hearing the matter, this Honorable Court had passed the order that the UGC will be required to be made as a party.
Any objections?
No, my lord.
You are for the
I'm for respondents 1, 2, and 3.
I number so and so, heard counsel for the applicant. This application is filed seeking impleadment of the University Grants Commission represented by its secretary. Stop. This application is filed in deference to the order dated 2/7/2026, wherein
Para 2. Yeah.
the court had considered that UGC would be a necessary party and therefore permitted the counsel for the petitioner to take appropriate steps for impleadment of UGC as a respondent in the writ petition. Stop. Para. Prayer for impleadment is not objected to by the counsel for the respondent. Accordingly, without issuing notice, accordingly, considering the order dated so-and-so, passed in WPC so-and-so, this IA is allowed at this stage without issuing notice. UGC, represented by its secretary, is directed to be impleaded as respondent number 4. Stop. Respondent number 4 in WPC 10/2024. Stop. Petitioner will file amended course title and in the registry within 1 week from today. Para. IA accordingly stands allowed, disposed of.
I'm over.
In the writ petition, you write, in view of the order passed today in IA number so-and-so, UGC is arrayed as respondent number 4. Petitioner will file amended course title within 1 week from today. The writ petition be listed thereafter.
I'm over.
Item 11.
May it please your lordship, this IA has been filed as the respondents have shifted their address during the pendency of the appeal. And white order dated 10/8/2026, we were allowed to bring on record the correct postal address. Hence, we have filed this application, my lord.
You have got the correct address.
Yes, my lord, at page 3, my lord, page 3,
Para 3.
para 3, yes, my lord.
Heard counsel for the applicant. Anyone for the respondents? No.
No.
Not yet.
Notice is not yet complete, my lord.
Right. Counsel for the respondents, this IA has been filed in the regular first appeal of 18/2026, whereby this court, by order dated 10/8/2026, permitted the counsel for the appellant to take necessary steps for bringing on record the correct address of respondents 2 and 3. Stop. Para, in deference to the said order, the IA has been filed Para 3, page 3 of the IA reflects the correct address of opposite party, respondents 2 and 3, namely so and so. Stop. Accordingly, considering the submissions made, this IA stands allowed. The petitioner is permitted to file amended course title in the registry reflecting the correct addresses of respondent 2 and 3. Let this amended course title be filed within
My lord, 3 days.
3 days.
Yes, my lord.
Okay.
Since today is Friday.
Within 3 days. And the regular first appeal be listed thereafter.
My
I
lord.
accordingly stands allowed, disposed of.
In the IA, if we may be, in the main appeal, if we may be allowed to take
You file
self
the,
notice.
you file the correct address.
Yes, my lord.
After that,
Yes, my lord.
if you want it, we'll list it on Thursday or any other date you want.
Yes, my lord. That will be listed on Thursday, my lord. That's-
Thursday. I accordingly stands, the RFA be listed on Thursday, 25th.
Obliged, my lord.
Item number 8.
8?
May it please your lordship, I'm reading.
Oh.
Your lordship, in item number 8, there is a status quo order regarding. Your lordship, item number 7 and 8, it has been tagged along. In item number 8, I am the appellant. I have challenged the probate's application, which was not granted. Actually, by an order dated 22nd of May 2025.
We've just taken up item 7.
Yes, your lordship. Item number 8 is a connected matter. In item number 8, there is a status quo order. That might be continued, your lordship.
All right, status quo order, if any. Is it till today?
Till today, it is the next
It's in the RFA.
RFA, your lordship. And we have a file in IA also. IA number 165.
I for what?
Your lordship, regarding the pendency of the appeal, the respondent had withdrawn the amount of 10 lakh. That is the subject matter of dispute in item number 7. So regarding, the appeal was already admitted.
The status quo order was passed in which matter?
RFA 19 along with IA number 165.
Where is the order of status quo? Status quo is directed to be maintained. Why is it necessary to be extended every day?
Then your lordship, till the disposal of the IA, your lordship may indicate, because
Status quo order passed on so and so will continue on so and so date will continue till disposal of the, until further orders by the court.
Item 12.
My lords, this RFA, my lords, if it may come up on Tuesday,
Sorry?
if it may come up on Tuesday, my lords, for final hearing, my lords. It was in the hearing list.
No, there is an IA.
Yes, my lords, along with the IA, because respondent number
IA
2.
is for substitution.
Yes. So if it may come up together, because the paper book has been made, my lords, of the.
No, but this IA is for substitution.
Yes.
Is there any order passed?
No, not yet.
Then, if you have to substitute,
Yes.
you'll have to substitute before you go for final hearing.
That's right.
Otherwise, how do you go for final hearing in the face of your substitution application?
My lords.
Substitution for respondent 2
Yes.
upon her demise.
Yes.
So she has to be substituted. Unless you say that they're on some any other point
No.
or on some agreed grounds, the appeal can be disposed of.
No objection insofar as my lords the respondents themselves.
Yes, Lordship, I'm appearing on behalf of my senior for the respondent number 1 and 2, my lord. And we have no objection.
We can allow this IA if
Yes.
you want.
My lords.
When did she expire?
Lords, sometime in June this year. It is within the limitation.
June of 26.
26.
9/6.
9/6.
You want it on Tuesday?
My lords, it may come.
All right, we'll take it up on Tuesday.
Item 13.
May it please your lordship.
Yes.
My lord, the instant appeal has been filed challenging the judgment and order dated 22/9/2023 that was passed in civil suit number 101 of 2011. My lord, wherein the respondent number 1 has been declared the rightful owner of the land, the portion of land which has been encroached by the lands of the instant appellants, and that the state respondents have been directed to cancel the LSCs of the appellants, my lord. My lord, the brief facts of the case, my lord, is that, if I may, my lord, the plaintiff, the respondent number 1 plaintiff, was issued a plot of land by the DC revenue in the year 1979, and in the year 1978 he was issued a plot of land, and in the year 1979 that plot of land was converted into 2 LSCs. One LSC was in the name of the respondent number 1, who is the plaintiff in the civil suit, and the other LSC was in the name of his wife. And after the death of his wife, he was issued airship certificate, white airship certificate number 53 of 2011, wherein he was declared the legal heir of the LSC left behind by his deceased wife. And in the meantime, in the year 1981, the father of the instant appellants, the appellants are brothers. The father of the appellant, Mr. Tlang Loma, was also issued an LSC, bearing LSC number 241 of 1981. And after his death in the year 2006, the said LSC was mutated in the name of the appellant number 1. The case of the plaintiff respondent number 1 in civil suit number 101 of 2011 is that LSC number 241 of 1981, which was issued in the name of the father of the appellants, had overlapped the 2 LSCs which belonged to him. Then he filed the complaint with the Revenue Department. However, no legal steps was taken. No legal recourses were taken by the respondent number 1. And pursuant to the survey that was conducted in the year 2010, my lord, the Revenue Department had directed and informed the appellant number 1 as well as the respondent number 1 to settle the dispute amicably. Otherwise, the land of the LSC of the appellant number 1 would be cancelled.
And the appellant and the opposite parties are what? Defendants are neighbors?
My lord.
Relations?
No relatives. No, there is no relation between the appellants and the respondent number 1. And being aggrieved that no steps was taken by the government in spite of notice under section 80 CPC, my lord, the respondent number 1 has filed civil suit number 101 of 2011, praying that the land of the instant appellants be cancelled and that he be declared the owner of the disputed lands, my lord. And the appellants who are arrayed as defendant number 1 and 3, they have filed a joint written statement. My lord, The civil suit 101 of 2011 starts from page number 1. And the appellants who were defendant number 1 and 3 in the civil suit, they have filed a common written statement. And in the preliminary objection, my lord, they have stated that the civil suit was barred by limitation. And also, my lord, that the respondent number 1, the plaintiff, had never taken possession of his LSC, whereas the appellants herein, the defendant number 1 and 3, had been living on their land since 1982. LSC was issued in the year 1981, and right after that, from the year 1982, it was contended that the defendant number 1 and number 3, who are the appellants in the instant appeal, they have been continuously living for more than 30 years, my lord. And that it was also submitted in the written statement that the LSC, which was issued in the name of their father, was further demarcated into 2 other LSC. One LSC belongs to the respondent number 3, and the other, the instant respondent number 2, herein, my lord. And the other LSC belongs, was issued in the name of the appellant number 2. And it was also contended that, my lord, the spot verification which was done in the year 2010, that was never conducted in their presence, and that being living on the same plot of land since the year 1982, my lord, if any survey had been conducted, that then they would have known. However, no survey had been conducted over their lands, my lord. That is the contention of the appellants here in their joint written statement, my lord. And my lord, the written statement, the joint written statements of the appellants are at page number 45. The respondent number 2 herein, my lord, he is the brother-in-law of the appellants, and he had purchased that one plot of land which was demarcated from the land which was issued in the name of Sri Tlangloma, father of the appellants. However, my lord, during the proceedings in the trial, the instant respondent number 1 and the respondent number 2 had come to an agreement, and they have executed an agreement wherein it was stated that the land of the respondent number 2 does not encroach or overlap upon the land of the respondent number 1. And my lord, the state government, who are rated as defendant number 4 to 6, they have stated that the LSC which was issued to the father of the appellants, that is LSC number 241 of 1981, was issued after NOC from no objection certificate from the village council as well as the neighbors were obtained. However, it was stated that the plaintiff and the appellant number 1 herein, my lord, they were informed to settle the dispute amicably. And after the pleadings were completed, my lord, the respondent number 1 plaintiff produced 3 witnesses who were examined and cross-examined. The appellants herein produced 3 witnesses, including themselves, and the instant respondent number 2 adduced no evidence, and the state respondents, they produced only 1 witness, my lord. And 5 issues, my lord, 5 issues were framed. This is at page number 184. And my lord, after hearing of the matter, the learned trial court come to the conclusion which, my lord, which starts from page number 167 of the paper book. 167 of the paper book. And the operative portion of the order, my lord, this is at page number 205. 205. The order reads, my lord, if I may.
Yes.
It is hereby declared that the LSC number 241 of 1981 being registered in the name of Sri Lalzuya, defendant number 1, and LSC number so and so being registered in the name of Sri C. Chuan Omar. These are the appellants herein, my lord. Have encroached upon the plaintiff's landed properties, that is LSC number so and so. The plaintiff is the rightful owner of the land encroached by the lands of the defendant number 1 and 3. The defendant number 1 and 3 shall hand over full and vacant possession of the plaintiff's land and which have been overlapped, encroached by the LSCs to the plaintiff within a period of 6 months from the date of this order. The defendant number 1 and 3 shall dismantle, remove the house buildings erected by them within the plaintiff's land within a period of 6 months from the date of this order. The defendant number 4 to 7 are directed to cancel the LSC number 241 of 1981 being registered in the name of Sri Lalzuya, defendant number 1, and the LSC number so and so being registered in the name of Sri C. Lal Chuan Omar, defendant number 3, within a period of 6 months from the date of this order. My lord, we are aggrieved with this order, and my lord, we are before this honorable
So
court.
what is the error in the order, in the judgment? What is the error?
My lord, our grounds starts from page number 225. Grounds.
225. You've seen the
225,
grounds.
my lord.
Yes. 225.
225. Paragraph 10. 225 of the paper book, my lord. The first
Suit maintainable or not had already been held to be maintainable by the predecessor judge of the
yes, my lord.
civil judge. Was there any revision or appeal filed against that order?
No, none, my lord.
Then
However, my lord, regarding that, my lord, I would like to take your lordship to section number 3 of the Limitation Act, my lord.
all right, we'll come back to that. Now, what are the other grounds?
My lord, the other grounds are that the LSCs of the appellants as well as the LSCs of the respondent number 1 herein were issued by the same authority, and that the issuance of the LSCs of the appellants, my lord, they were done after following proper procedure established as per law, my lord. That they have, prior to issuance of the LSC, my lord, to the appellants, the concerned authority had also obtained an NOC from the village council wherein the land was situated, and also NOC from the neighbors, my lord, from the neighboring landowners. However, my lord, in spite of that, our LSCs were declared to be invalid.
Under what provision these LSCs are issued? Under what law? What are the preconditions?
My lord, if I may take your lordship at page number 241, page number 18. Page number 18, 18. The land of the LSC of the appellants, the father of the appellant, my lord, that is been issued under section 2 of the Mizo District Land and Revenue Act 1956.
What does the provision say?
My lord, the terms and conditions of settlement are at page number 19. Page number 19.
No, these are the conditions of settlement.
My lord.
Under what provision can a settlement be issued?
My lord, this has been issued under section 11 of the Mizo
What
District.
does,
Yes.
what does section 11 of the Act say? Section, this
My lord,
Mizo District Land Revenue Act.
I will My lord, I will come to that, my lord. And page number 14, my lord, page number 10 and page number 14. These are also these are the lands of the respondent number 1, the plaintiff in civil suit. And my lord, they have also been issued under the same law, the same provision of law. My lord, section 11 reads, if I may, my lord.
Section?
Section 11, my lord, of the Mizo District Land and Revenue Act 1956.
Yes, section 11.
Yes, section 11. Certificate of possession and assessment, if I may read.
Yes.
A settlement holder shall, on completion of survey and demarcation of boundary, obtain a certificate of recording for the details of that payment of such amount of recording fee as may be prescribed. Different rates of fees may be prescribed for any local area or class of land. So, my lord, the precondition is that survey and demarcation of boundary. Now, for this survey, my lord, NOC was issued by the competent, by the concerned local body, village council, and also from the neighbors, my lord. And if your lordship could kindly come at page number 20.
You're referring to?
Page number 20, my lord.
Of the Act?
No, no, my lord, of the paper book. Page number 20 of the paper book.
Page number 20.
My lord. Now, this is the site plan of house for Mr. Klang Loma, father of the appellants, my lord. And the boundary of the lands, my lord, these are clearly mentioned. In fact, my lord, this have been demarcated by a surveyor.
Was this brought on evidence?
Yes, my lord.
This is your land?
Yes, this is my land. This is my land. And my lord.
Which was interfered with?
Yes, my lord.
Yes.
And my lord, if your lordship could kindly see the land of the respondent number 1 are nowhere reflected on the neighboring lands, my lord.
Where is the finding of the court with regard to this evidence?
Lord. My lord, this is that issue number 4. It starts from page number 203. Issue number 4. Whether the plot of lands belonging to the plaintiff and the plot of lands belonging to the defendants, number 1 to 3, are encroaching upon, overlapping each other. If so, which of the LSCs will prevail?
No, then you have to go to issue number 3.
My lord. Whether the LSC number 241 of 1981, my lord, this is the
This is, the
This is the
241
original.
is whose land?
this is the land of the appellants, my lord.
241.
Yes, which was
Interfered.
initially, yes, which was firstly issued in the name of their father, Mr. Tlangloma. And the site plan, the map is page number 20.
Then?
And LSC number 337 of 2006. My lord, as I have already stated, my lord, LSC number 241 of 1981 was demarcated further into two other LSCs, 337 of 2006 and 338 of 2006, my lord.
This belongs to, this
337 of 2006 belongs to the instant respondent number 2. (337) belongs to instant respondent number 2.
appellant was the defendant.
Yes, my lord.
Defendant number?
Appellants were defendant number 1 and 3.
And this 337 belong to the plaintiff.
No, 337 belongs to the respondent number 2, who was also defendant number 2 in the civil suit.
Yes.
And LSC number 338 of 2006 belongs to the appellant number 2.
Appellant number 2 is D3.
Yes, D3.
Now, this LSC 241,
My lord.
after it was demarcated,
My lord.
was there any land under 241?
Yes, my lord. Land under 241 of 1981 still existed.
Still exists.
Still existed.
In whose
and
name?
It is in the name of the appellant number 1.
Okay.
Appellant number 1.
Appellant 1 is D1.
Yes, D1.
And 338 is D2.
No, my lord. 338 is
D3.
D3. Appellant number 2.
D3. Okay.
Now, the plaintiff, the instant respondent number 2 herein, did not dispute the land of the respondent number 2, my lord, because they had made an agreement stating that the lands does not encroach upon each other. There was an agreement, signed agreement, my lord. Now, the finding of the learned trial court, my lord, is that the concerned authority, the revenue department, had issued LSC in the name of Sri Tlangloma, the appellant's father, my lord, without knowing that there was already land settled on that same plot of land in favor of the respondent number 1. That is the finding of the learned trial court. And that in order to issue a land, my lord, the land has to be a vacant land. That is the finding of the learned trial court. And also, my lord, the learned trial court had relied heavily on the survey report which was done in the year 2010. And that, my lord, we have completely denied, we have absolutely denied that any survey had had taken place within the disputed land, and my lord, that we were never informed of the survey, even though we have been continuously living in the suit land
Was it a
from
part of
1980.
the, was it a part of the evidence?
Yes, my lord, part of evidence. Even the plaintiff, the respondent number one, had stated that in his cross-examination, he had stated that if there was any survey conducted over the disputed land, the appellants or his family member would have known.
But you take us through the issue number 3.
My lord. My lord, issue number 3. Now, my lord, the plaintiff, my lord, he had stated that he had a plot of land which were allotted in the name, as well as in the name of his wife. The two LSCs were 241 of 1979. 241 of 1979, this is the LSC belonging to the plaintiff, respondent number 1. And LSC number 424 of 1979, this was issued in the name of his wife. And on the death of his wife in the year 2009, my lord, he was issued heirship certificate number 53 of 2011, and he was declared legal heir to the property left behind by his wife, that is LSC number 424 of 1979.
Yes.
And my lord, it is a case of the plaintiff, my lord, that as soon as they learned that the LSC had been overlapped by the lands of the appellants, my lord, he personally went to the revenue department and made a complaint.
Yes.
Even though, my lord, he had stated that a survey was conducted over the suit lands, my lord, no notice, no letter or order for such survey was ever conveyed to the appellants or their family. And it is a case of the plaintiff, my lord, that physical verification on the disputed land was conducted on 16/8/2010. On 16/8/2010, wherein, my lord, it was stated that the appellant number 1 herein had constructed a house over the land of the plaintiff.
Yes.
And my lord, the learned trial court had also taken this point that the LSCs which was issued in the name of the appellants, my lord, this was issued carelessly without verifying the factual position. And
where is the report of the
my lord,
someone has submitted a spot verification report?
yes, my lord.
Who is the person here? Surveyor.
Surveyor, my lord.
Where is the report of the surveyor?
My lord, this is at page number 23. 23, it starts from
Page 23.
Page, my lord. My lord, it starts from page number 36.
36.
36, yes. 36 translated version is at page number 37. This is a letter written by the surveyor to the assistant settlement officer. The forwarding letter, my lord. Forwarding letter of the verification report, and the verification the operative portion, my lord. This will start from paragraph number 2 and 3, page number 37.
This is the forwarding letter.
Yes.
Where is the report?
Forwarding letter, my lord, report is not annexed in the.
Was it called
during
for?
trial?
Was it before the trial judge?
No, it was never produced, ma'am. Only this letter.
All
And
right.
page number 38 is the order. Now, page number 37, my lord, paragraph number 2, it reads, if I may, my lord, translated version.
Yes.
Mr. T. Lalonghagliana on LSC number 241 of 79 and Mr. Lalzuya on LSC number 241 of 81. And these two lands precisely overlap each other. Now, Mr. T. Lalonghagliana, my lord, this is the plaintiff in the civil suit. And Mr. Lalzuya was the defendant number 1. Lalzuya has constructed a house in this area and he currently resides here. It would be worthwhile to mention that he has segregated his land area into 3 different parts. I have submitted this report for further necessary action from your end. Now, the detailed survey report, my lord, that has not been brought before the trial court. And pursuant to this letter, my lord, an order was issued by the assistant settlement officer. It's at page number 38. The English translated version is at page number 39.
Where is the order dated 16/8/2010? Or some survey was conducted on 16/8/2010.
My lord.
Is it available?
Survey, no, my lord. Survey report that is not available on record.
Not available.
Yes.
Where is the order dated 28/9/2010?
My lord, this starts from page number 38. This is the vernacular.
38.
Yes. English translated version is at page number 39.
39.
If I may read, my lord. The dispute between LSC number so and so owned by Mr. Tilal Hablian Ebin Peng and his neighbor LSC number so and so owned by Mr. Lalzuya has been spot verified on 16/8/2010. On the date of spot verification, it is identified that Mr. Lalzuya's house construction site and the area segregated by him has encroached and overlapped Mr. Tilal Habliana's house site. On the date of verification, Mr. Lalzuya was advised to have proper negotiation and discussion with Mr. T. Lalonghaglian in order to have an agreement. This is because his overlapped LSC was junior to landowner. It is learned that Mr. Lazio did not approach or have any discussion in this matter with Mr. Tilan Hakliana. He is again instructed to discuss the matter at the earliest, that is, on or before 10/10/2010. If no discussion is carried out by him during this period, action will be taken as per the office rules to the extent that his LSC may even be cancelled.
Then,
Now, my lord, these two, the surveyor nor the concerned authority who had issued this order, my lord, they were never produced before the court to adduce evidence or to substantiate this, to prove this document, my lord. Only one.
what about this? What about this page 37? This was also not proved.
Not proved, my lord. Not proved. However, my lord, in spite of the fact that these two documents, my lord, having not proved, yet the learned trial court had relied on the judgment passed by this honorable court at page number 203.
$203.
Yes.
Ah.
And my lord,
What is the judgment?
my lord, the judgment is RFA number 10 of 2014.
For what? For to what extent?
To the extent that allotment of land can only be done in respect of vacant land.
Yes.
So, my lord, the learned trial court had heavily relied on the forwarding letter issued by the surveyor as well as the order passed by the assistant settlement officer. However, my lord, those documents, my lord, those were not proved during the proceedings of the trial, my lord, of the case. That is another ground. And my lord, the another ground is that while taking a decision as to whether the land of the appellants had encroached upon the land of the respondent number one, my lord, the learned trial court ought to have taken into consideration the boundary descriptions that was attached along with the LSC, my lord, particularly the site plan of the respective LSCs. Because, my lord, property can be identified, my lord, by its boundary, which is a well-settled law, my lord. However, in spite of that, and in spite of the fact that the land, the boundary descriptions, the site map of the lands of the appellants nowhere shows that the appellant was the immediate neighbor, man. And another ground, my lord,
So this was the primary ground,
my lord,
this document.
my lord.
And then,
Another ground is that, my lord, the suit being filed after 30 years from the date of knowledge of the alleged encroachment by the respondent number 1 had only come to
that was held to be maintainable by the predecessor judge. That order was there.
my lord,
You choose not to challenge it.
my lord, that is there, my lord.
Then,
However, my lord, we have taken that as a ground because, my lord, section 27, my lord, of the Limitation Act provides that the extinguishment of rights to property. It is also, my lord, it is also not the case of the respondent number 1 that he did not know that his land was encroached upon by encroached by the appellants. In fact, he had stated, and it is recorded evidence that he had known that the appellants had encroached upon his land as early as 1982.
where is that evidence?
Page number 115. My lord, the examination in chief of the plaintiff,
Is there a typed
respondent
copy?
number 1 starts from 108.
Is there a typed copy?
No, my lord, type copy is not here, unfortunately. My lord.
Examination in chief of the plaintiff is
It starts from page number 108.
108.
Yes. And the cross-examination starts from page number 114.
Yes.
And if I may take your lordship, page number 115, serial number 10. Page number 115, serial number 10. If I may read. I came to know that Putlang Loma's land had overlapped my land in the year 1981 or 1982.
Yes.
And my lord, again at page number 117, 117, serial number 22. Here he had stated the reason why he had not approached the court, my lord. Page number 117, paragraph number 22. Although I know that I could approach the court for legal reasons, I did not approach only due to the advice of my grandfather, who was a pastor. He knew his rights, my lord. However, he chose not to exercise the same, my lord.
Yes. Then,
So, my lord, having settled continuously undisturbed, my lord, until the filing of the civil suit in the year 2011, having settled within the land continuously for more than 30 years, my lord, and having paid revenue taxes regularly, and that the competent revenue authority having accepted the payment of tax that was done by the appellants, my lord, the impugned judgment, my lord, ought to have been set aside and quashed. And I have some I would like to rely on some authorities, my lord. 2010, volume 4 SCC 491.
You have given a list of books.
I have given a citation memo, my lord, only citation memo.
Okay. Tell me, what is this?
2010, volume 4 SCC 491, paragraph number 25, my lord. Here it says mere admission of documents, my lord, is not proof of its contents. Paragraph number 25. If I may read them.
Yes.
We are of the firm opinion that mere admission of a document in evidence does not amount to its proof. In other words, mere marking of exhibit on a document does not dispense with its proof, which is required to be done in accordance with law. The learned, my lord, the learned trial court relied heavily on the letter issued by the surveyor as well as the order.
The paragraph number?
25.
25.
Paragraph number 25.
Okay.
And my lord, regarding the a property can be identified by its boundary, my lord, I would like to rely on two judgments. 2006, volume 5, SCC 466. 2006, volume 5, SCC 466. Paragraph number 6, my lord. Paragraph number 6. Paragraph number 6. My lord, I would like to read from the 5th line. That a property can be identified either by boundary or by any other specific description is well established. Here the attempt had been to identify the suit property with reference to the boundaries, and the commissioner has identified the property with reference to such boundaries. Even if there was any discrepancy, normally the boundaries should prevail. There was no occasion to spin a theory that it was necessary in this suit to survey all the adjacent lands to find out whether an encroachment was made in the land belonging to the plaintiff.
This is against you.
No, my lord. The boundary descriptions, my lord, boundary descriptions of my land, these are clearly reflected at page number 20. So, my lord, the trial court ought to have relied.
That is disputed. The dispute is with regard to that only.
My lord, if your lordship will come to the evidence of the plaintiff, he had clearly stated that the LSC had been issued in the name of the appellants, as well as payment taxes have been paid, my lord. So the respondent number 1 did not dispute that LSC was issued in my favor, and that it was
That is the dispute, that the LSC could not have been issued in your favor in view of the fact it was overlapping his land. Therefore, the LSC issued was not as per proper survey. This is his ground.
My lord,
So
is
therefore,
also,
the boundary, therefore, the identification of the land which you are claiming on the basis of the boundary ordinarily is there unless there is a dispute raised.
my lord, it is also not dispute that NOC was issued by the concerned village council as well as the neighbors.
All right.
Prior to issuance of my LSCs. That was not disputed. And my lord, 2015, volume 13, SCC 673. My lord, this also relates to properties identifiable by boundaries.
2015?
15, volume 13, 13, SCC 673,
Para
para 11.
11.
Para 11. The object of the above provision is that the description of the property must be sufficient to identify it. The property can be identifiable by boundaries or by number in public record of settlement or survey.
Yes.
My lord, and regarding the limitation period, my lord, even though the case was maintained, and that has not been challenged, my lord. However, my lord, I would like, with your lordship's permission, my lord, I would like to take your lordship's to page section 3 of the Limitation Act, my lord, if I may just read the
Limitation.
provision.
Yes. Yes.
My lord, bar of limitation, subject to the provisions contained in section 4 to 24, inclusive, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. My lord, in the instant case, if we look at the plaintiff in the civil suit, the plaintiff had done some clever drafting, my lord. He had not stated the exact date when he had come as to his knowledge of the encroachment. He had simply stated that the cause of action first arose when the plaintiff came to know of the encroachment. However, no date, no year was mentioned, my lord. There was some clever drafting, my lord. However, in the cross-examination of the plaintiff, my lord, he had stated clearly that it was in the year 1981 or 1982. And my lord, by the time evidence were adduced, the suit was already maintained, my lord.
Yes.
That is why, my lord, this point was not raised before the trial court, my lord. And my lord, in the instant case, no application under section 5 of the Limitation Act was filed for condonation of delay. And article 65 of the schedule, my lord, clearly prescribed a period of 12 years. Period of 12 years.
Article?
Article 65 of the schedule, my lord, Limitation Act. Whereas the plaintiff, the respondent number 1, he had stated that he had come to the knowledge in the year 1981 or 1982. Then, my lord, by the time of filing the civil suit in 2011, my lord, the period of limitation had already expired. And my lord, I would like to rely on 2008 volume 14 SCC 445.
2008.
14 SCC 445. Paragraph 32 and 33.
Yes.
If I may read. Now, limitation goes to the root of the matter. If a suit, appeal, or application is barred by limitation, a court or an adjudicating authority has no jurisdiction, power, or authority to entertain such suit, appeal, or application and decide it on merits. 33, my lord, it reproduces section 3 of the Limitation Act, subsection 1. Bare reading of the aforesaid provision leaves no room for doubt that if a suit is instituted, appeal is preferred, or application is made after the prescribed period, it has to be dismissed even though no such plea has been raised or defense had been set up. In other words, even in absence of such plea by the defendant, respondent, or opponent, the court or authority must dismiss such suit, appeal, or application if it is satisfied that the suit, appeal, or application is barred by limitation. Now, my lord, even the learned trial court, my lord, at the time of filing, my lord, since no specific date was given as to when the cause of action arose, this, my lord, this is clearly reflected at para number 15 of the plaint in civil suit number 101 of 2011 at page number 7.
You were saying that no specific
date was given.
Date of knowledge.
Yes, date of knowledge. It only says that the cause of action in the suit first arose when the plaintiff's landed property covered by so-and-so was illegally issued and overlaid by LSC number so-and-so without permission of the plaintiff. No date given, man. No date, no year. Page number 7, paragraph number 15. This is the plaint in civil suit, man. And my lord, the case being filed beyond the period of limitation and also without any application for condonation or delay, my lord, I would like to rely on another judgment, 2009 volume 6 SCC 194. volume 6 SCC 194, paragraph number 70.
One minute.
My lord.
Paragraph?
Paragraph 70, my lord.
70.
My lord. I would like to start from the 5th line, my lord. Those applications were also filed after expiry of the period of limitation, and none of those applications were also accompanied with the application for condonation of delay. In absence of any application for condonation of delay, the court had no jurisdiction in terms of Section 3 of the Limitation Act, my lord. So, my lord, our humble prayer is that the learned trial court, having relied heavily on the spot verification report, even though the same was not proved by way of evidence, my lord, and that the survey report itself having not been included in the records, my lord, and also the fact that the appellants herein, my lord, they were never present on such survey report. The learned trial court honored to have, my lord,
Yes.
so our humble prayer is that the impugned judgment and order, my lord, may be set aside in quashment.
Okay. Yes.
May I please, your lordship?
Yes.
I'm the respondent number 1 in the instant RFA and the plaintiff in the civil suit number 101 of 2011,
Yes.
lordship. The judgment and order passed by the trial court, that is Civil Judge Senior Division 3.
Just 1 minute. The appellants, how many appellants are here?
2, my lord.
Defendant 1 and 3.
1 and 3 only. 1 and 3.
1 minute. Yes.
Lordship, that the judgment and order passed by the trial court, that is Civil Judge Senior Division 3 Aizol on dated 22/9/2023 is just and proper, and with application of mine, lordship, the judgment order was passed. As such, there is in the judgment and order, lordship, there is no any legal and factual error committed by the trial court, lordship. The learned appellant lordship has hesitated a lot regarding that during the conduct of the inquiry reports by the Revenue Department. Lordship, the appellant has been given several times notice that he never turned up. Lordship, in the page number 26 of the paper book, lordship. Page number 26. May I read, lordship? That to Mr. Laljuya, son of Plang Loma, late Din Thardeving Aizol, regarding the LSC owned by you and Mr. Dilal Ngakliana at Din Thardeving, you have been called at the office of the for discussion about this matter on 4/8/2099 and 12/8/2099. As only Mr. Dilal Ngakliana, that is present respondent lordship turn up, and since you did not show up that days, we are unable to have further discussion on dated 14/9 1999, Tuesday at 11 a.m. Mr. El Malsoma, ASO2, will be coming to your land site along with Mr. Thang Puya, Surveyor 2, and Mr. Van Sanga Silo, Surveyor 2. You are instructed to be present on the spot with your LSCC document on that day. So prior to the conduct of the verification, he has been given notice, and not one, 2 times he was also called in the office, but he never turned up, Lordship. Then thereafter, Lordship, this page 37 and 39, Lordship, this of the paper book.
What were the earlier page numbers?
Pardon?
You just read out the page numbers earlier.
Page number, Lordship, this 37, 39. 38, 39, Lordship, this.
38 and 39.
Yes, Lordship. Annexure 2 paper, that is in paper book, page 38, Lordship.
37 and 30. Sorry. 37 and 39.
38, 39, Lordship.
38, 39.
Yes. This 37 is, Lordship, it is a report submitted by the surveyor. May I read, Lordship? Report on land verification. Memo number such and such dated 7/7, that is, as mentioned in the above order number, I have performed spot verifications of the land owned by Mr. Lalnghagliana and Laljuya on dated 16/8/2010. Mr. Lalnghagliana owned LSC number 241 of 1979, and Mr. Laljuya owned LSC 241 1981. And those two LSC precisely overlap each other. Laljuya has constructed a house in this area, and he currently resided here. I would be worthwhile to mention that he has segregated his land area into 3 different parts. I have submitted this report for further necessary action for your end. That is, this report is submitted by this surveyor, Joe Ranga, Lordship. That is on dated 17/8/2010. And there is a order, Lordship, another order, that is page 38 of the paper book. That is 39 is the English translation, Lordship. That is 38, it is a Mizo version, and 39 is the English translation, Lordship. The disputed between LSC 241 of 1974, owned by Mr. Tilal Ngagliana Edin Tarveng, and his neighbor LSC number 241 of 1981, owned by Laljuya, has been spot verified on dated 16/8/2010. On the date of spot verification, it is identified that Laljuya has house construction site, and the area segregated by him has encroached and overlapped Mr. Tilal Ngagliana house site. On the date of verification, Mr. Laljuya was advised to have proper negotiation and discuss with Mr. Lalnghagliana in order to have an agreement. This is because his overlap LSC was junior to the other land's owner. That is, the respondent land is much senior than the appellant, Lordship. It is learned that Mr. Laljuya did not approach or have any discussion in this matter with Mr. Tilal Ngagliana. He is again instructed to discuss the matter at the earliest, that is on or before 10/10/2010. If no discussion is carried out by him during this period, action will be taken as per the office rules to the extent that his LSC may be cancelled. This is the report, Lordship, this by the Assistant Settlement Officer, Land Revenue and Settlement Department, Aizawl, Lordship.
Was any order passed pursuant to this order for cancellation? Obviously not.
As the matter, as they have, it was pending before the court, Lordship, that is before the trial court.
No. This letter was issued on 28th of September 2010.
Yes, Lordship.
Pursuant to that, obviously no order was passed for cancellation of the LSC.
I have no knowledge, sorry, Lordship.
No
Trial
cancellation order was passed.
because and they have come to the court, that is the landowner has come before the trial court, Lordship.
Yes.
That is why during the pendency,
That is the plaintiff.
Yeah, plaintiff.
Who you represent.
Yes. So during the pendency, I think Revenue Department has not taken any necessary action for cancellation of the past, Lordship. However, Lordship, this is a proof that the land of the respondent has been overlapped by the, it is a evidence, Lordship.
Yes.
And thereafter, Lordship, during the trial court has also examined the Revenue Department, that is Under Secretary to the Government of Mizoram, and a Revenue Department, that is, Lordship, page, Lordship, that is 165, 66, Lordship. 165, 165, and
Yes.
Lordship, this is the Zoming Thanga, Under Secretary, Land Revenue and Settlement Department, Government of Mizoram. It is his deposition before the trial court, Lordship, that the plaintiff and his wife, Langhak Liana, were allotted a plot of land covered by LSC number 241 of 1979 and 224 of 1979 respectively. That thereafter, presuming the land to be a free land, as NOC were obtained from the then VC and the neighboring land, LSC number 241 of 1981 was issued to Tlang Loma, that is son of Thangkima, that is who is the father of the present appellant, Lordship. That the said land LSC 241 of 1981 was portioned into 3 LSCC, that is in the year 2006, that the defendant number 1 was also informed that unless amicable settlement could be reached, necessary action, even cancellation of LSC, might be taken as the LSC is, as his LSC is junior to the LSC of the plaintiff.
This is in so far as page number 39.
Yes, Lord.
In respect of page 37, is there anything? Any evidence?
37, Lordship, that is cross-examination. May I go through, Lordship?
Yes.
That is cross-examination. It is a fact that we have...
No, page number?
Page number 166, Lordship.
166. Yes.
It is a fact that we had stated in para 12 of our written statement.
This is cross-examination?
Yes, cross-examination.
Of?
That is cross-examination of Under Secretary Revenue.
Under Secretary. Okay.
Yes. Sri Zoming Thanga. It is a fact that we had stated in para 12 of our written statement and para number 4 of my examination in chief that the defendant number 1 was informed that unless amicable settlement with the plaintiff could be reached, necessary action for cancellation of his LSC might be taken, as this LSC 241 of 1981 was junior to the plaintiff LSC number 241 of 1979 and 424 of 1979. It is a fact that it is the law of our land, it is our law of land law that cancellation of junior LSC in case of any overlapping of encroachment. It is a fact that the land was allotted LSC number 241 of 1981 by encroaching upon the plaintiff land LSC number 241 of 1979 and 424 of 1979. It is a fact that the private defendants were cancelled to the private defendants were called to the office of the Land Revenue Settlement Department. It is a fact that department has been supporting the plaintiff since the beginning of the dispute till today. It is a fact that the polls fall in this. So this is the evidence of the Undersecretary, that is Land Revenue Department, who are the concerned department of the landlordship. This is their finding. So this evidence is not rebutted by the defendant. Is the present appellant. So the fact remains that the land of the respondent was overlapped by the present appellant lordship. And in this case, lordship, as many as 5, that is 5 issues were framed by the trial court lordship. Those 5 issues were whether the suit is maintainable in the present form and style, whether the LSC number 241 of 79 and 424 of 79 were valid or not, whether the LSC number 241 of 1981 and LSC number that is 2006 are validly issued or not. Lordship, in this issue, if we go through that, the trial court finding is that these LSC of the present appellants are not issued in a proper manner, as they have not maintained any formalities, Lordship, and they should have been obtained the opinion, that is the no objection from the neighboring country. But either if they have been issued validly, either respondent, that is plaintiff, opinion must be obtained. My opinion is not obtained, Lordship, when the LSC was issued in favor of the present appellant, Lordship. That is the lacuna on the part of the Revenue Department, Lordship. So how can they issue without only obtaining the no objection from the that is local council or village council, Lordship? They should have been, and the map which they have prepared, it should be, if even though supposing it is not overlapping my land, that I shall be in the site map, that there must be boundary description, that my name must be mentioned there, that this northern side, southern part, that there must be boundary description, must be clearly mentioned. All those things are not maintained by the issuing authority, Lordship. As such, the revenue that is passed, that is that is the LSCC of 241, and this it is 1981. It is merely issue on presumption, without proper conduction, without proper verification, without proper measurement at the time of the issuing of this LSCC, Lordship. So, Lordship, all the issues are decided in favor of the plaintiff, Lordship, and nothing is remained, Lordship, as per evidence of the Land Revenue Department and as per the evidence of the others, that it is very clear that the LSC belonging to the respondent is overlapping my land. It is illegally issued and without my knowledge. Regarding that condonation of the Lordship, the trial court has trial court has already decided that the case is maintainable, Lordship.
Sorry, case is maintainable.
Yes, case is maintainable. That is why that regarding that condonation part, Lordship, it is already overcome by this respondent, Lordship. Respondent claims. It is maintainable. So issue number 1 was that is, Lordship, let me.
Oh, that is the ground of the counsel for the appellant. This was wrongly held to be maintainable because in view of Section 3, the Limitation Act.
Yes. Yes.
So
yes,
what-
they have submitted, they have hesitated even in before the trial court, Lordship. But it is maintained by the trial court, Lordship. Now at present, if freshly they have hesitated, that is only, Lordship, it is up to your Lordship whether the matter can reopened for the maintainability of the case, Lordship. That regarding the judgment and order, Lordship, as per the judgment and order passed by the trial court, issue number 1, Lordship, issue number 1, that is, Lordship, in their application, Lordship, page 35A. Issue number 1, whether the suit is maintainable in its present form and style. The learned producers court had by order dated 17 September 2012 held that the case is maintainable and no further journey is necessary. And the issue number 2, whether the LSC 241 of 1971 and LSC number 424 of the 1979 are valid or not. There were no evidence to have shown that the LSC number 241 of 1979 and LSC number 424 of 79 were not valid. That even before the trial court, Lordship, the present appellant cannot show any evidence, either in documents or either in oral evidence, that the LSC belonging to the respondent is invalid or it is issued by not maintaining the proper procedure, this and that. They have accepted that my LSCC have been issued in a proper way and they have not challenged at all regarding the validity of my LSC, Lordship. And issue number 3, Lordship, whether the LSC number 241 of 1981 and LSC number 337 of 2006 and 338 of 2006 are validly issued or not. The plaintiff, as PWD 13 LB Chetri, plaintiff witness number 3, stated in their examination in chief that the plaintiff was allotted a plot of land at Dintharveng, Aizawl by the Land and Revenue Settlement Department, Government of Mizoram, and the said plot of land was allotted in the name of the plaintiff and his wife, LSC number 241 of 1979 and 421 of 79 were issued in the name of the plaintiff and his name of the and in the name of the plaintiff wife, Lalthiang Limi, respectively, with an area of the 0.09 biga each. The plaintiff wife passed away on 25/10/2009 and the plaintiff had been declared as the legal heir of his wife in respect of LSC number 424 of 1979, vide his heirship certificate number 53 of 2011. The defendant number 5, 6 and 7 Land Revenue Settlement Department illegally issued LSC number 241 of 1981 in favor of Sri Thangloma, father of the defendant, that is Laljuya, that is defendant number 1 and 3, within the plaintiff plot of land LSC covered 241 of 1979 and 424 of 1979. After the death of Sri Tlang Loma, his son, his LSC 241 of 1981 was mutated in the name of Lalzuya, that is present appellant. It is mutated in the present appellant. As soon as the plaintiff learned that the LSC 241 of 79 and 2479 were overlapped by the LSC 241 of 81, he personally went to the Land Revenue Department. Lordship,
It's just fell out of a file. Put it properly. RFA 130 something, huh? Must be there in some item. Yes.
Lordship, this operative portion that is regarding this issue number 3, Lordship, that is page 38A2, page 39 and page 39, Lordship. This is the operative portion, Lordship. That is, the defendant number 2 were illegally issued by the defendant number
38?
38A. That is in their petition, Lordship, appeal, page 38 of appeal petition.
38?
Yes, page 38A.
38A.
Yes.
No, 38 is
In the appeal
order dated.
Yes, yes, order of the trial court, Lordship. That is the decision of the issue number 3.
You are referring to the decision of the issue.
Yes, decision of
in
the issue.
impugned judgment.
Yes.
That is which paragraph?
Para, Lordship, that is
issue number 3. Issue number 2.
Yes, issue number 3, Lordship.
3.
Yes, issue number 3.
Yes.
Issue number 3. Lordship, this that the LSC 241 of 1981 was issued overlapping his plot of land. On further inquiry, the plaintiff came to know that besides the said LSC 241 of 1981, two LSCs were also issued out of that is made into 3 part, Lordship. Defendant number 2 and LSC number 338 2006 issue in the name of Sri C. Lalsuan Oma. Defendant number 3 were illegally issued by the defendant number 4, 5, and 6 within the land already allotted to the plaintiff LSC 241 of 1979 and LSC number 424 of 79. The concerned surveyor, namely Sri Zauthanga, Land Revenue and Settlement Department, Aizawl, Mizoram, submitted his spot verification report of the said matter of the land that dispute between the plaintiff and the Sri Lalzuya, defendant number 1, to the ASO 1, Land Revenue Settlement Department, Aizawl, Mizoram, wherein he stated clearly that the boundary and the area of the plaintiff plot of land was exactly same as in the compliance with the description made in the LSC, and further he mentioned that the said LSC 241 of 1981 overlapped the plaintiff plot of land. That means, according to the findings of the trial court in issue number 3, Lordship, this LSC of the present appellant the boundary description was exactly like the land of the respondent number 1, Lordship.
Okay.
And Lordship, the Land Revenue Settlement Department, Aizawl, Mizoram, had issued an order, white order dated 28/9/2010, stating that physical verification on the disputed land of the plaintiff and the defendant number 1 was conducted on 16/8/2010, wherein he had stated that Sri Lalzuya LSC number 241 of 1981, wherein he had built a house and he divided 3 LSCs clearly overlapped the plaintiff plots of land. And further, Sri Lalzuya was even directed to approach the settlement to settle the matter and issue the plaintiff as his LSC and his slice out divided LSC overlapping the plaintiff plot of land as his LSCC was issued later than the plaintiff LSC. However, Sri Laljuya, that is the present appellant, paid no heed and said order and still continue to illegally occupy the said land in spite of the said order and the strong objection from the part of the plaintiff. Therefore, Sri Laljuya was again given another time to settle the matter with the plaintiff and the plaintiff by the Land Revenue and Settlement Department, Aizawl, Mizoram, on dated 10/10/2000. That is, he has given several times, Lordship, to settle the matter and to reconcile, but he refused very often, failing which he would be taken an even cancellation of his LSC. The defendant number 7, ASU1, Land Revenue and Settlement Department, Aizawl, even after issuing the said order dated 28/9/2010, the defendant number 1 and 3 still continue to illegally occupy the plaintiff plot of land in spite of the said order and strong objection from the plaintiff. It was an admitted fact that the said LSC 241 of 1981 issued in favor of Sri Laljuya, that is his father, it was issued and the said LSC number, that is 337 and 338, in the name of Roy Koma, and LSC number 338 issue in the name of Sri C. Lalsuan Oma, were clearly issued without verifying the factual position and the encroachment of the said land 241 of 1979. So this is the findings of the trial court and the decision of the in issue number 3, Lordship. That is even issue number 4, Lordship, that is
main contention would be issue number 3.
Yes, issue number 3.
Issue number 1 and issue number 3.
Yes, issue number 1 and issue number 3.
Right.
So that issue number 4, Lordship, whether the plot of land belonging to the plaintiff and the plot of land belonging to the defendant number.
Any judgments you are referring to? Any citations you'd like to refer to or rely on?
Lordship, yes, that there is a there is a decision, Lordship, even that the land that is land passed, senior to senior, the senior of the land pass issue should be sustained.
Where is that?
Lordship, I'll give.
We'll continue on Monday.
All right, Lordship.
Monday, evening. All right. Monday. Third counsel for the parties for further hearing on Monday.
Supplementary list. Item number 14 for admission.
This must be there, no? These are my notes. But I'm sure it doesn't get disappeared.
Hello.
Yes, please.
Lordship, I was in this post yesterday. I could not come.
No, not an issue. We had fixed it for today.
Lordship, this is RFA from civil suit number 19 of 2017, arising out of the judgment which is passed by the learned trial court. The copy which I have enclosed here.
Is it for final disposal or who's for the other side?
It's for motion only, Lordship.
Admission.
Admission.
Okay, it's not admitted as yet.
It has not been admitted.
All right, we'll admit it. We'll
first
call
time-
for the records. We'll admit and call for the records.
Right, Lordship.
But Mr. C. Lalam Sawa, Senior Counsel, assisted by Mr. So-and-so, for the appellant and learned government advocate, appearing for the respondents.
Respondent number 2 and 3, Your Lordship.
Respondent 2,
2 and 3.
2 and 3.
Respondent number 1 is a private respondent.
Then,
I believe that notice has to be issued.
okay. Uh, Appearing for the state respondents. However, therefore, no formal notice be issued on respondent number 3 and 4, I think.
Respondent number 2 and 3 is the state respondent, Your Lordship.
Is it? Where is your appeal memo?
Hmm. 2 and 3.
Okay, respondent 2 and 3. Therefore, no formal notice need be issued. Steps on respondent 1 by speed post within 1 week from today. The appeal be admitted and the trial court records be called for. Matter be listed immediately after the returnable date.
Lordship, we have an interim prayer. Status quo as on today may be maintained, or the operation of the judgment in order may be
Till
stayed.
the next returnable date, status quo be maintained between the parties in respect of the judgment dated so-and-so passed by so-and-so court. Matter be listed again on 22nd of September.
For orders, item number 15.
May it please Your Lordship, I appear on behalf of the state respondents number 1 to 4. Your Lordship, I have taken the consent of the learned senior counsel. Your Lordship, if this matter may be listed again next week as on a date convenient for the learned senior counsel, because Your Lordship, today I have a personal difficulty.
Convenience is that of the court, priority wise.
Yes, Your Lordship. My apologies, Your Lordship.
But yes, tell us, when do you want it?
If it may kindly, Lordship, be taken up on Monday.
Monday?
If possible. If possible.
Monday is good for you?
Yes, Your Lordship.
All right.
Much obliged, Your Lordship.
As agreed to.
Attempt, my lord, attempt may kindly be taken for disposal.
All right. Monday, what is the matter about?
It's actually a prayer for calculation for compensation, my lord, land acquisition.
Okay. On a prayer made by the council, state council appearing for the respondents, matter is listed on Monday. Attempt will be made to dispose of the matter. Then it should come for admission. Why is it for orders?
It's registry made it up on that.
Matter be listed for
Admission. Hearing.
It was a part-heard matter.
Earlier, my lord, but now released.
It has been released from the part heard. It has been released, Your Lordship.
Okay. Matter be listed for admission on Monday.
Obliged.
Much obliged, Your Lordship.
Part 2 hearing list, item number 17.
Yes. Yes.
May it please Your Lordship. My lord, this relates to service matters. The petitioner was appointed as an officer of the Mizoram Rural Bank.
Appointed as a?
Officer of the Mizoram Rural Bank in the year on 26/07 to 1988. And his service was regularized after 2 years of service as a probationary officer on 30/01/1992 with effect from 26/07/1990. And my lord, while he was serving as a branch manager at Serkon in Lunglei. An FIR was lodged against him for misappropriation of funds. And then, my lord, he was dismissed from service thereafter. Even though the criminal case that was charged against him.
You're a legal aid counsel?
My lord, I'm the legal aid counsel.
Okay. Yeah. Yes, please.
My lord. FIR was filed against him on 30/05/2006. My lord, this is at Annexure 2, page number 24. Page number 24. For alleged misappropriation of rupees 14,96,000. However, my lord, via judgment and order dated 29/03/2010, the petitioner was acquitted by the magistrate first class, Lunglei. This is at page starts from page number 25, annexure number 3. And my lord, on 11/10/2006, he was issued a memorandum of charge. This starts from page number 27, annexure number 4. And in the memorandum of charge, my lord, the respondent authorities have annexed these articles, four charges, my lord. Page number 28. Page number 28, the true type copy, my lord.
Is it your case that the inquiry report was not furnished?
Yes, my lord. Inquiry report was not furnished.
What do the respondents say in their affidavit?
In fact, my lord, after inquiry report was of 2007, of the year 2007, and that even on application under RTI Act, that was not furnished to me.
No, in the affidavit, what is the stand of the bank?
My lord, the stand is that, firstly, the petitioner had approached this honorable court after 17 years.
No, regarding
Regarding misappropriation of funds, my lord.
No. Service or the furnishing of the inquiry report. It is your case that inquiry report not furnished.
My lord.
So what is the stand of the respondents here in their affidavit? Is it denied or you filed an appeal before the appellate authority?
My lord.
Without the inquiry report?
My lord. I have applied for the copy of the inquiry report. That was not furnished to me, and I have filed an RTI appeal. And the Chief Information Commission had directed the respondents to issue those reports, and I was issued those reports only in the year of December 2021.
And this is an inquiry for which year?
Inquiry of 2007.
2007. And when did you file the appeal?
Before the
Appellate authority?
Before the appellate authority, my lord. My lord, the copy of the inquiry, the appeal, my lord, that has not been annexed. However, the copy of the order, my lord, that is annexed at the hearing.
Who's for the respondent bank?
I'm your lordship.
Has the inquiry report was submitted?
Initially, my lord, I think it was not furnished to him, that preliminary inquiry. But after charge was
not
framed.
Not preliminary, the inquiry which was conducted
Conducted, my lord, it was furnished to him. And he was also served memorandum of charge. And he was also duly informed to submit his defense statement of defense, my lord. That he duly do that, my lord. That is also enclosed herein in the petition along with the other appeal petition, and which I also in my affidavit, my lord, have enclosed herein.
Now, after that,
He admitted, my lord.
all right, but after that, the inquiry report is not next year.
It is
After the inquiry, I mean, after the inquiry, the report will have to be submitted, isn't it?
inquiry report, my lord. Yes, he's not enclosed herein, I think.
In your affidavit, have you mentioned anything about that?
I have mentioned that that was done, my lord. After he applied for it through RTI, my lord, he was furnished copy of the inquiry report also.
Which paragraph?
Kindly bear with me, lordship.
My lord, if I may take your lordship at page number 56
Oh,
of the writ petition, my lord. Annexure 13. This is the reply I have received from the respondent, my lord. We,
inquiry report could not be traced out.
yes. And thereafter, page number 58. Page number 56, letter is dated 07/12/2021. And at page number 58, letter dated 23/12/2021. Now, Xerox copy of the inquiry report, my lord, that has been.
It was furnished.
Yes, only on 23rd December. Prior to this, my lord, no report, no inquiry report was furnished to me.
Okay. So what was the punishment imposed?
My lord, I was dismissed from service.
Where is that order?
My lord, the order, my lord, this will be at page number 47. 47, annexure 9. Page number 47, annexure 9.
This was issued on 7 June 2007.
Yes, my lord.
Oh. Where are the copies of the rules?
My lord, copies of the rules have not been enclosed along with the petition, my lord.
Respondents, is there a copy of the rules available? Is it the state rules that you adopt?
No, my
or
lord, there is
separate rules?
bank officer rules is there, my lord.
Separate rules?
Separate rule is there.
I will need a copy of that.
Apologies, my lord, I do not have it now, my lord.
Give us next week,
My lord.
Monday or Monday?
Monday.
My lord, Monday, there was a part heard matter which we have just.
Tuesday?
That RFA?
Yes, that are the.
Ah.
So if another day maybe.
You have already concluded your arguments, you prepare this matter.
My lord, I would like to make some reply, my lord, if your lordship permits.
All right,
Any day.
let us keep it on Monday, let us see. If you are not able
My
to
lord,
do it, we'll see.
My lord.
Monday, to be listed on Monday, on which date the respondents will place a copy of the rules followed by the bank in respect of the departmental proceedings initiated against the petitioner. which culminated into the order of, impugned order of dismissal.
My lord.
Release this matter again on Monday.
My lord.
We could just mention item 2, my lords. We had inadvertently, my lords, forgot to seek your lordship's indulgence insofar as extending the interim orders. It's fixed for Monday.
Monday? What is going to happen down the weekend?
My lords, we are just, my lords, being taken.
All right, interim order, if any, will continue till the next date of listing. Item number 2.
So grateful, please.
Then?
Lordship, one item, my lord, if I may be allowed, my lord. There is one item which I'd like to mention, my lord, for next week, my lord. If this may kindly be allowed, my lord, to be taken up for hearing, my lord.
For hearing?
My lord. Actually, as of now, in the prepared list, my lord, it is not there, my lord. That is why.
What is the item? I mean, what
It is about land compensation, my lord.
Land compensation.
My lord. There is a.
All right, Monday?
Monday, my lord.
Let it be on Monday, let us see.
My lord. Obliged.